Hello everyone, I'm Jeff Hampton with the Fulgham Law Firm. Welcome to our YouTube channel. Today I want to talk to you about assault. Is it possible to get an assault charge dismissed? By the way, if you wait around till the end of this video, I will also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Okay, now let's just jump right into determining what does Texas law say the crime of assault actually is. Now, under the Texas Penal Code, section 22.01 defines assault as intentionally, knowingly, or recklessly causing bodily injury to another, or intentionally or knowingly threatening another with imminent bodily injury, or intentionally or knowingly causing an offensive or provocative contact with another, all right? Now, here's the thing. I'm going to talk today more generally about the distinctions between the types of crimes of assault, okay? Texas law will grade assault and make assault anywhere from a ticket citation all the way up to something you could spend literally lifetime in prison for, depending upon the nature of the assault. So when I talk about assault, it's kind of a blanket term that covers multiple areas. For example, assault can involve a stranger, a friend, a family member, a romantic partner. Domestic violence is a separate allegation or a separate designation that has its own set of specific consequences as a result of that. But generally, when we just use the term assault, it's kind of talking about a misdemeanor assault, and it can take on different forms. One would be assault, bodily injury, maybe aggravated assault, maybe domestic violence. And then there's the crimes of threats, terroristic threats, different things like that, okay? Now let's talk for a few moments, and I'm going to break this down. When you start talking about the seriousness of the charge, what are the penalties? When we're looking at assault is going to be graded based upon the harm that was actually inflicted or the threat that was made towards the individual. So let's first start off with the Class C misdemeanor of assault by contact. Now, assault by contact essentially means that someone contacts another person and the contact was offensive. What does that mean? I have no idea. So for different people, it means different things. It's very subjective. I've talked about this before, but you could be walking down the grocery store and you accidentally make a turn down one of the lines there and you accidentally bump into someone, and someone might think that you're a jerk and now all of a sudden claim that they were offended, right? So what's offensive for someone may not be offensive for another person. Now, as a result of that, there was no injury. So what does the law say? The law says that assault by contact is punishable by fine only. So you can pay up to a $500 fine, but be careful. If you go in and pay that fine, you are doing the same thing as pleading guilty. It's a conviction, and it is now on your record. Particularly if the person involved in the allegation was a family member or a loved one or a roommate. Because an assault by contact family member allegation, you'll have to actually get fingerprinted, be put on a register where you can actually be made, people will know, the state of Texas will know and label you as a violent offender. So even though it seems like a minor thing, be careful how you work out that type of charge. Now let's move our way up. What about a Class A misdemeanor of assault bodily injury? Assault bodily injury is when someone contacts another person and it causes them an injury. Well, what does that mean? It means pain. So there doesn't necessarily have to be visible marks or injuries or bruising, but it makes the case much weaker if there's not visible proof of it, if there's not some type of extraneous evidence to prove it. Otherwise, it's someone's word, okay? So we look at this, it literally only requires someone to say, ouch, that hurt. That is punishable by up to a year in county jail and up to a $4,000 fine. Then we work our way up to a third-degree felony. How do we get to a felony charge? Well, if you have an assault of a family member that with a prior conviction for an assault of a family member, that can make it a third-degree felony. All right. What if you have issues? What if there are charges related to a harassment or an assault of a public servant? An assault of a public servant means if you get into an altercation with a police officer and they sustain any type of injury, that's also a third-degree felony. And that is punishable by up to 10 years in prison and up to a $10,000 fine. Then you get to the second-degree felony. Second-degree felony, example of that would be an aggravated assault with a deadly weapon, okay? or certain sexual assault. So it really depends, but the main one I'm going to spend time talking about is the aggravated assault deadly weapon. Now, let me tell you this. Aggravated assault deadly weapon is essentially, there's a couple of ways it can be proven. One is it can be an aggravated assault by threat. Number two, it can be an aggravated assault serious bodily injury. Number three, it can be aggravated assault deadly weapon. Now, an aggravated assault by threat is if someone has, let's say they take what looks like could be a gun or a knife, and they look at the person and they say something so threatening that it places that person in fear of imminent serious bodily injury or death. The mere threat of it alone could result in someone being charged with a second-degree felony. You say, whoa, wait a minute. No one was actually hurt. You mean to tell me if that person says that they were in fear of serious bodily injury or death, that they can still face the same type of charge that if someone pulls out a gun and shoots someone? The answer to that is yes, okay? So that's aggravated assault by threat. What about an aggravated assault serious bodily injury? Listen, if someone, let's define serious bodily injury. If someone sustains a type of injury that results in a permanent loss of use or a protracted loss of use of a bodily member or organ of their body, like they're permanently crippled, or their face is deformed, or they're unable to use a part of their body like they did before the incident, you can actually be charged with an aggravated assault serious bodily injury. And then finally, aggravated assault deadly weapon. If someone assaults another person and a deadly weapon is used in the commission of that crime, you could be facing a second-degree felony. And remember, a second-degree felony is up to 20 years in prison and up to a $10,000 fine. You can get into other types of assaults that are a first-degree felony. For instance, an aggravated sexual assault. You can have an aggravated assault with a deadly weapon with an enhancement, or if there's a previous conviction that exists. These are all ways where, these are all different types of ways where an assault charge could be elevated to where a range of punishment could be anywhere between 5 all the way up to life in prison. Now, I'm not going to go over in detail. I encourage you to go back through some of our other videos, but let me give you just a quick sample of some possible defenses. Number one is self-defense. If someone else did something to you and you were acting in defense of yourself, that by itself is if it's justifiable that what you did, that can be what's called an affirmative defense, which means now the state of Texas will have to prove you did not act in self-defense, and they will have to prove that beyond a reasonable doubt. So number one, self-defense. Number two, what if you had no intent? What if there was no criminal intent? The state of Texas has to prove that whatever happened here happened intentionally or knowingly. In other words, what if it happened accidentally? What if the contact was something incidental and not as the result of something you meant to do? If that's the case, you may have a valid defense. Number three, what if the witness's statements are not credible? You have an alleged victim here who's just not being credible in anything that they're saying. Their story doesn't add up. It doesn't make sense. Well, there, your attorney can attack that either through cross-examination during a jury trial or potentially be able to expose those issues with the grand jury if you're facing a felony assault. Finally, what about no injury? Now, here's a big one. If there's no injury, but someone's claiming, oh, that hurt so bad, here are all these things that happened to me, but yet there's no evidence of it. Sometimes I see police officers taking pictures of people's arms or legs, and I mean, they look great. There's nothing wrong with them at all. There's no injuries. In that situation, it makes for a much weaker case because there's no actual extraneous proof. There's nothing else to bolster or to back up the credibility of this potential witness, okay? Finally, if your case is a felony, you should hire an attorney as soon as you're able to do so, because that attorney may be able to present certain evidence that we're talking about here today to the grand jury. That grand jury could take your assault case, your felony assault, potentially either have it lowered to a lesser charge, down to a misdemeanor level offense, or maybe even receive a no bill on your case. A no bill is the equivalent of being acquitted. The case is being thrown out. And then at that point, your case would be eligible to be expunged from your record. Now, I gave you a lot of information, but I wanted to kind of paint a picture for you, give you the landscape of this type of crime in Texas. Maybe you're facing this type of allegation for yourself. Maybe you or a loved one is looking at an assault charge. And maybe you're in the North Texas area. Don't hesitate to contact the Fulgham Law Firm at 817-877-3030. We would be happy to give you a free consultation and try to help kind of line out for you what your next steps are. By the way, if you enjoyed this video, please like the video, subscribe to our channel. We'll be happy to send you more great content just like this. And since you waited around to the end of the video, I'm going to give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Look down below on the link, expand it on YouTube, take a look at it down there at the bottom, and you'll click on that link at the very bottom, fill in your information. We'll be happy to send you the free ebook. And don't hesitate to give us a call. Thanks for joining us here today at the Fulgham Law Firm.